Yes, Mr. Quest.
My lords, my lady, I appear with Mr. Scott Ralston for the appellant at UBS. The second claimant and respondent, Ace Decade, appears by Mr. Saad Hussain, King's Counsel, and Mr. Matthew Hoyle. First claimant and respondent, Mr. Kwok Ho Wan, is not represented, although his US trustee in bankruptcy has written to the court saying he takes a neutral position on the appeal.
Yes.
And so far as we're concerned, his position on the appeal does not differ from that of Ace Decade, and we don't propose to say anything separate about him. The third claimant, Dawn State, is not involved in the appeal, there being no challenge to jurisdiction in respect of its claim.
Yes.
As you know, this appeal is made with the permission of the judge below against her decision to accept jurisdiction over the claims of Ace Decade under Articles 5.3 and 5.5 of the Lugano Convention. And like the judge, I will first address the issues arising under Article 5.3 and grounds 1 and 2 of the appeal. The first part of this appeal raises the question of where damage occurs for the purpose of the Lugano Convention when a person invests in reliance on a negligent misstatement or on negligent advice. The factual context is set out quite fully in the judgment, but if I may, I will just briefly summarise the key facts as we see them. Ace Decade is a British Virgin Islands company, and its claim, in essence, is that in reliance on negligent misstatements and negligent advice that it received from UBS in Hong Kong, it made an investment referable to shares in Haitong, a Chinese company listed on the Hong Kong Stock Exchange. And I say deliberately that the investment was referable to those shares because, for perfectly proper regulatory reasons, the investment was deliberately structured so that Ace Decade would not itself acquire the Haitong shares and would not itself acquire any interest in them. The investment instead took the form of a contract between Ace Decade, on the one hand, a Chinese investment manager called Haixia was the second party, and the third party was another BVI company called Dawn State that was then a subsidiary of the Chinese investment manager Haixia, and which was intended to act as a vehicle for acquiring the Haitong shares. And that investment contract, which is called a co-investment agreement, was made in China. And what it provided, and perhaps actually we can turn it up, it's in the supplemental bundle at page 257, tab B3. It provided, in summary, that the Dawn State Company would subscribe to 1.25 billion in dollars in newly issued shares in Haitong.
So you're 257 in the
supplemental bundle.
Supplemental bundle, the co-investment agreement.
Co-investment agreement.
Yes, thanks.
And your Lordships will see the parties identified. And just to summarise, what was provided is that there would be a subscription by Dawn State to $1.25 billion in shares to be issued by Haitong. And the subscription was to be funded, as one sees in the second paragraph, at $500 million by way of a monetary contribution to be provided by Ace Decade, and $750 million in the form of leverage to be borrowed by Dawn State. And in return for its contribution under this agreement, its $500 million contribution, the right that Ace Decade acquired, and one sees this at paragraph 1.2 over the page, the right that Ace Decade acquired was a right to share in distributions from Dawn State, that being the capital C company. And that right to a distribution, your Lordship will see, if we go over the page again, at section 3, the nature of that right was set out in the agreement. And the agreement provides, in the introductory paragraph that the right conferred hereunder represents a contractual right on the part of the investor being Ace Decade, to participate in the project, and shall not be construed of any of the following: A, conferring on the investor a right or interest in Heixia Fund, Heixia Management, the shares of the company, the target company, or any interest deriving from it whatsoever, and as not construed as conferring on the investor a right or an interest, direct or indirect, legal, beneficial, or equitable, in any shares or any other shares or securities of the target company, that being Hai Tong, which may be held by Dawn State after completion of the project. So the right was deliberately and specifically contractual. I should note also that separately from this agreement, there was a separate letter agreement, which is in the previous tab, B2, which gave Ace Decade an option to acquire the shares in Dawn State from Heixia. And that option was eventually exercised, but only after the events giving rise to the present proceedings. The evidence does not show from where or to where Ace Decade was to pay its $500 million monetary contribution, but the inference seems to be that it was paid in China, and at any rate, there's no suggestion that that money was paid or received in England. So far as the loan was concerned, the $750 million was lent to Dawn State by UBS London branch. In addition, when Dawn State acquired the shares in Hai Tong, those shares were held in a custody account in the name of Dawn State with UBS London. And UBS London held those shares as security for the loan it had made to Dawn State. And UBS and Dawn State entered into a number of agreements to give effect to that arrangement, including a loan agreement, a custody agreement, and a security agreement. But Ace Decade, as investor, was not party to any of those agreements, and indeed had no contractual relationship at all with any UBS entity. So that was the form of the investment. After the investment was completed, there was then a substantial drop in the Chinese stock markets, including the Hong Kong stock market. And the price of the underlying Hai Tong shares declined very rapidly from the beginning of July 2015. That triggered a demand by UBS, because of the reduction in the value of its security, for repayment of the loan by Dawn State. And when Dawn State did not repay the loan, UBS exercised a right under its security agreement with Dawn State to sell the Hai Tong shares from the custody account and to apply the proceeds against the loan. The sale price realised on that sale was such as to leave only a modest surplus available to Dawn State after repayment of the loan, and therefore only a modest amount, about $4.7 million, which was available for distribution by Dawn State to Ace Decade under the co-investment agreement. So the investment to that extent was a failure. So those are the facts, and just one other point to note on those facts. It is not part of Ace Decade's complaint that the sale of the shares by UBS London amounted to a breach of any duty owed by UBS London to Ace Decade, although there is a separate complaint made by Dawn State about the operation of the agreement, but the appeal's not concerned with that. So that's the factual background, and against that background, I now turn to ground one of the appeal, which concerns the test that the judge applied in considering Article 5.3 of the Lugano Convention. Before I get to more controversial issues, there are a number of aspects of the jurisdictional regime under Lugano and under Brussels regime which appear to be essentially undisputed, and they're largely set out in paragraphs 42 to 45 of the judgment, but let me just summarise them. First, the principal basis of jurisdiction under the Brussels-Lugano scheme is domicile. So the general rule is that a defendant should be sued in its state of domicile, and the special jurisdictions, including that under 5.3, operate only as derogations from the general rule, which is described, as the judge mentioned it, as having overriding importance. And it follows from that that any exceptions to the domicile rule have to be construed restrictively, and that the burden is on the claimant to show that there is justification for derogating from the general rule of domicile. Second, as regards 5.3, the judge sets out the text of Article 5.3 in paragraph 44 of her judgment. The text refers to there being jurisdiction in the courts for the place where the harmful event occurred, or may occur. But it's common ground that is interpreted as having two different limbs and applies either to the place where the damage occurred or the place of the harmful event that caused the damage. And as you will have seen in the present case, only the first limb is relied on, only the occurrence of damage limb, and that is no doubt because the harmful event that caused the damage was the alleged negligent misstatement or negligent advice, and that is not in dispute, occurred in Hong Kong and not in England. The third undisputed point, or uncontroversial point, is that the place, and this comes from the decision of the Court of Justice in Dumez, and is referred to in the judgment of paragraph 59, the place where damage occurred is taken to mean the place where the causal event giving rise to tortious liability directly produced the harmful events in relation to the person who is the immediate victim. It's got to directly produce the harmful events in relation to the person who is the immediate victim of the tort. And the fourth point is that the place where the damage occurred under the Lugano Convention is taken to mean the place where the initial damage manifested itself. And one sees this word manifestation frequently used in the European cases, and it's a word that the judge obviously attached some importance to. But in our submission, simply resorting to that word manifestation as a descriptor doesn't answer the question of what it actually means in the context of pure financial loss. And likewise, whilst the objectives of the Convention, certainty, predictability, sound administration of justice, are also not in dispute, they themselves do not answer the question which arises on this appeal, which is when financial loss occurs as a result of a misrepresentation, where should that be treated as occurring? In her judgment and in granting permission to appeal, the judge said that the authorities, both European and English, on the occurrence of purely financial damage under Article 5.3 were difficult and unclear, which in our submission is a fair comment. And so before I turn to look at the authorities which the judge referred to, it is in our submission helpful to consider the question as a matter of first principle or first impression. What I mean by that is this, that when a person complains that they've suffered financial damage by investing in reliance on a misrepresentation, what are they really complaining about? What they're complaining about, in my submission, is that they've parted with money to acquire an investment when otherwise they would not have acquired that investment, and that they've not got their money back, or not all of it.
Mr. Quest, can you imagine any circumstances in which this claim would have been brought if the shares had not fallen through the floor?
Well, my lord, if the shares had always been above their initial value, then of course the claim would not have been formulated as a difference in value between them. But in theory, it would still have been open to the claimant in those circumstances.
Is Article 5.3 about theory or practice?
Well, I'm not sure it's about theory or practice. It's about setting a rule for jurisdiction by way of derogation from domicile that arises in particular prescribed circumstances. And to answer your Lordship's question, whilst whether they would have pursued this as a commercial matter, who knows, but it would have been entitled at any point, whether the shares were above or below the original strike price, for the claimant to say, I do not want to be in this arrangement. I've entered into this arrangement on the basis of misrepresentation. As matters stand, the share price is still high, but it may go low. I'm exposed to a risk I did not expect to be exposed to, and I wish to bring a claim to extricate myself from this arrangement. And it may be that that claim would only be for the value of unwinding the transaction rather than the much larger amounts that are claimed here. But there is damage caused by entering into an arrangement that you didn't expect to enter into. And on that basis, the claim can always be brought. To revert to the point I was making, what the nature of the objection, the nature of the complaint in a case like this is a person saying, I've parted with money for an investment that otherwise I wouldn't have made. I wouldn't have made this investment in the first place. And I haven't got my money back, or I haven't got all of it back, or I might not get it back, or I'm exposed to further risks. And that really is the gist of a complaint that the person makes in a case like this. And that indeed is the way in which Ace Decade puts its claim, pleads its claiming damages. And if your Lordship and your Ladyship can turn up pleading, which is in tab 10 of the core bundle, the pleading of loss is at paragraph, ends at paragraph 83. Under the heading Ace Decade's claim. And paragraph 83 sets out...
You've got to read them together, haven't you?
83 and 84, yes. There's just, paragraph 83 sets out the things that it says it did on reliance on the representations, including entry into the co-investment agreement, the various other things. And 84 sets out the loss and damage caused, which is in three parts. First of all, it says it's lost the entirety of its monetary contribution, which was the money put in at the beginning, less what it got back. Sub 2 is essentially the same claim, but is adjusted slightly to reflect the fact that if it had exited or if it had chosen not to invest at an earlier stage, it would have avoided having to pay a fee. So that's the difference between 1 and 2.
Where is the alternative investment claim pleaded?
Well, as I understand it, it's pleaded at sub 3. In other words, there's a claim for losses representing returns which it would have achieved from investing in the UBS AG shares. Now, that's not really spelled out, but since it didn't in fact invest in the UBS AG shares, that seems to be a suggestion that it would have done it in some other way. And that being so, in our submission, in the absence of, and obviously we'll come on to the authorities in a moment, but just as a matter of first impression, as an absence of specific authority, if one's seeking to localise the damage caused by investing in reliance on a misrepresentation, one would logically expect to focus on the place where the investor made the investment, where it entered into or acquired the investment, and or, we'll come to this distinction later, the place where the investor paid for it, or where it received the return on it. And I say that's a logical position to take, because it's logical having regard to what was said in the Dumez case about looking to the direct and immediate loss caused to the immediate victim of the tort. Because those things, the acquisition of the investment and the paying out of the money, and or the not receiving the money back, those are the things that produce the direct and immediate harmful effect on the investor as a result of his having acted on the misrepresentation.
I mean, Mr. Quest, why is the substance of this claim not the investment, as you say, but the complaint that you enforced all this against me without giving me a chance to pay in longer time when you said you wouldn't. I was told you would not do that.
Because the complaint about enforcement would be a complaint for a breach of some of the contractual arrangements with UBS.
No,
that's the claim.
No, but representation is what is complained about.
Yes, but the nature of a claim in misrepresentation is the claim is not a claim for a breach of a promise. The claim is not advanced on the basis that UBS promised that it wouldn't enforce.
Not UBS, but that Mr. Kwok was told by Mr. Wong.
Right. So the claim is brought as a claim in misrepresentation. The claim is not pleaded, it's not advanced by UBS by Ace Decade on the basis that UBS promised that it wouldn't enforce.
So it's about the agreement, not what happened later, as it were. The position leading up to the agreement. And
Yes, it's
not
a
what happened after.
Right. Now, as I said, there is a complaint for breach of contract. There is a complaint for improper enforcement.
But that's Dawn State.
That's Dawn State's claim. But Dawn State, of course, is party to that contract, and Dawn State is perfectly entitled to say, if it's right, that there was a breach of that contract in enforcement. That's not the claim by Ace Decade, and it's not the claim by Mr. Kwok. Their claim is a classic misrepresentation claim, which is to say, well, I only invested in this in the first place because you told me this is how it would work. You told me this was the policy of UBS. You told me, he's not saying you promised that and I'm suing you for breach of your promise. He's saying you represented this to me and because of that representation I invested and I suffered a loss accordingly. That's the nature of the game. That's how it's pleaded.
That would make all the difference, would it, if it had been put the other way?
Well, if it had been a contract claim, we wouldn't be in Article 5.3 at all.
No.
We'd be in Article 5.1, and we'll be looking to the place of performance. We're looking at entirely different considerations. So yes, I quite see the point that as Master Ridol's indicated, that in other circumstances there might be claims in a situation like this which could be formulated as a breach of contract, and under which the court might or might not have jurisdiction under Article 5.1. But that's not this claim, and that's not the basis on which Ace Decade sought to.
But it's not what I put to you either, Mr. Quest. What I put to you was that the substance of the claim was that you represented, it was represented to me
Yes.
by UBS that its London branch would not enforce in certain circumstances, and you did.
And absolutely. Well, that's what's said, and that's what makes the representation. That's what's said
Makes
to make the representation to false.
Yeah.
And that's what's said, therefore, to give rise to the claim in misrepresentation.
Yes.
And therefore, one looks at the loss, which of course, and representation claims are always based on reliance, and therefore, because the claim has been formulated in that way, and that's not just a pleading issue. It's because there's a different kind of claim.
Well, that's important when you keep saying formulated, but you say this is a point of substance, not form.
Yes. I mean, the difference between a contractual claim for damages because someone breached a promise that they made and a claim in misrepresentation that I did something in reliance on what you represented, that's a very important difference in substance, not least because, and sorry to repeat the point, not least because jurisdiction arises under different provisions of the Convention. And the provision that's relied on here is indeed Article 5.3, which talks about tortious liability. And tortious damages are, of course, different from contractual damages as well. One has to look at what the claim is, both the way it's pleaded and what the claim is in substance. And that ought to focus attention on what the representee, what the alleged representee did in reliance on the representation, because that's the nature of the claim.
But that is the harmful event limb. That is the conduct limb, not the damage limb.
Well, with respect that the harmful event limb focuses on the making of the representation itself.
Yeah. Well, and also the part of the allegation, the part of the claim, which says you acted on the representation. I mean, a misrepresentation claim is fairly simple, isn't it?
Yeah.
It's a representation. You acted on the representation. The representation was false and was made negligent. Those are the elements of it in English.
That's right. And the harmful event limb focuses in my submission on
the two first ones.
On representation and reliance, but then the damage limb focus also necessarily also looks to what the claimant did, because it's in the nature of a representation claim that someone is saying, well, I suffered loss because I acted in a particular way in reliance.
Yes, but my point to you is there are 5 elements of the tort. The last one is damage, and the damage limb that is common ground as having been, there are 2 aspects to Article 5.3, is what you're focusing on here. And the substance, the point I've made to you now 3 times, and I promise not to make it again.
Yes.
The substance of the damage here is that I suffered loss because the representation you made to me did not come true.
Yes.
When the unfortunate events occurred.
That's the substance of the complaint. Yes. Because that's always the substance of a misrepresentation case. You said something to me, and what you said turned out not to be right. But the focus for Article 5.3 has to be on, of course, on where the damage is, and the submission I'm making is that in a, and we'll get onto the authorities in a moment, that in a reliance on a misrepresentation type case, one would expect the localization of the damage to be focused on what the defendant did by way of entering into the investment and paying for the investment, because those are the things that have the direct effect on the investment.
So what the cases show is that what's really important is the word manifestation,
yes,
as you admitted or accepted a while ago, and the substantive manifestation here is when the representation turned out to be untrue, which was not known at any stage until it actually happened.
Well, if I may, that raises a slightly different question, which is when, in a case like this, the claimant is aware that there is a problem, or aware that he has a claim. That's more, if I may, connected with issues about detection and learning when you've got a claim, rather than what the loss is that you've actually suffered.
But it's about substance. See, what I'm trying to explore is why, under an autonomous European piece of legislation, we should not be looking at substance rather than form, or elements of an English cause of action. And that the substance here is that there really wasn't anything to complain about until that representation turned out to be false.
Well,
damage was sustained.
I mean, on Ace Decade's case, the representation was false from the outset.
Of course they have to say.
And at any point that they discovered, and to that extent, they had a cause of action that they could have brought at any point. Of course, they couldn't bring it until they.
But what I'm putting to you is that is true, but theoretical. And if you're looking at an autonomous European construction of a statute that must be applied to English law and French law and German law and Romanian law, that's not really the substance of it.
Well, Lord, I think I'd have to disagree with that respectfully. I'm not suggesting that. I'm not trying to draw a distinction between form and substance here. What I'm saying is that the substance of the complaint here is that money was laid out and investment was acquired when it otherwise wouldn't have been, and that is the substance of the complaint in my submission. When the complaint is formulated as a misrepresentation claim. Now, it may be.
I understand.
I think, Mr. Quest, we may be taking you out of the course of your submissions, and the answer to some of my Lord's questions so far as your submissions are concerned will come when we look at the authorities.
I will come to it when we look at the authorities, but I'm happy to answer the question. Now the judge, of course, took a very different approach. She focused on the location of the event that, as she put it, crystallised the loss to Ace Decade. meaning, at least as she explained it, the event that caused the loss to become ascertained, which event, she said, was the sale of the shares from Dawn State's custody account. And if I could just ask you to look in her judgment at the relevant paragraphs, which are really, I think the conclusion is really paragraphs 112 to 115. I won't read them out, but if perhaps you could just remind yourselves of what she said in 112, 113, 114 and 115.
Yes.
Now, now for reasons I'll come to in a moment, our submission is that it was contrary to the authorities to focus on the event of crystallisation, and that none of the European or English decisions have held that jurisdiction can be established in that way. But before I do so, can I just identify some problems in our respectful submission with the way in which the judge dealt with the facts here? And particularly if one looks at paragraph 115, where she says that the money was lost to the claimants in London, where the shares they'd invested in were held, and where the funds they'd invested in were depleted. And the problem with that in my submission is that by referring to the claimants collectively, the judge is obscuring a very important distinction between the position of Dawn State on the one hand and Ace Decade on the other. Because, of course, it was not Ace Decade, but Dawn State that had acquired and held the Kaitong shares in the custody account in London. That custody account, which is what the judge refers to at paragraph 113 as the secured account, was an account in the name of Dawn State, created under the security agreement between Dawn State and UBS. So far as Ace Decade was concerned, Ace Decade had never acquired or held any shares in Haitong. It had never held any funds or assets or accounts at UBS London. Ace Decade had never had any dealings with UBS London at all. Its contractual relationship was exclusively with Haitzia and Ace Decade in China, and its rights and obligations in relation to the investment were exclusively rights and obligations under the co-investment agreement. Now, in paragraph 115, in the second sentence, the judge criticises our making that distinction as one which is artificial. But in my submission, it's important to recognise that the whole purpose of this investment structure was to ensure that Ace Decade did not acquire any interests in the underlying Haitong shares, and to ensure that its rights as an investor were confined to those arising under the co-investment agreement in China. And it's not, in my submission, artificial. Indeed, it's critical for the court to focus on what the parties themselves agreed should be the form and structure of their investment. And again, I would say that's not just a point about form. It goes to the nature of the investment that Ace Decade is making. And and again, when in paragraph 113, the judge refers to the loss manifesting directly in the secured account. That secured account was an account of Dawn State. It was not an account of Ace Decade, and no loss manifested itself in any account held by Ace Decade. In my submission, the fundamental mistake that the judge made with respect in trying to find the crystallising event is this: that the amount of the expected return to Ace Decade under this investment, of course, depended on the share price. I mean, I accept that point. As the share price fluctuated, the expected return from the co-investment agreement would fluctuate with it. Now, by July 2015, that had fallen below the price, had already fallen below the price at which Ace Decade had invested. And it may be right to say, as the judge does, that it was only when the shares were actually sold that the precise amount of the loss could be ascertained. But that, in my submission, doesn't mean that no damage occurred until that sale, nor does it mean that the sale of the shares was the damage. It may have affected the quantification of the damage, but that's not to say it was the damage. And in particular, it doesn't mean that the place of the sale should be treated as the place of the damage, which is the ultimate question we're looking at. Now, turning to the authorities themselves, the judge considered 5 main cases in the EU Court of Justice.
And apologies for interrupting. It may or may not be that is fairly established on domestic authorities, but do you say that the European authorities are to similar effect?
Yes, yes. I'm saying that it's not an easy exercise, but one can derive a principle that sort of runs through all of the cases. I should say one of the reasons it's not an easy exercise looking at the European authorities is that some of the cases are about where jurisdiction isn't, if I can put it that way, rather than where jurisdiction is. And that makes it all the more difficult to try and establish a positive rule from those authorities. Because
what is the principle that you say we're going to see emanating from all the European authorities?
So the principle, I would say, emanates from two principles arise, or there'll be 2 conclusions that we'll be able to draw from the European authorities. One is that they do not support, none of them supports the judge's analysis that jurisdiction can be established in a place of an event that crystallises a loss. So that's the first point. And the second conclusion I'll be making is that the only investment cases in which the Court of Justice has permitted jurisdiction to be established under the damage limit are cases where the investment was made in the place where jurisdiction is sought. Those 2 cases will come to them, Kalasa and Loba. So if I just then run through them, the first case, which is at tab 11 of the authorities bundle, is Kronhofer. Just to summarise the facts, Mr. Kronhofer was Austrian domiciled, and in reliance on the advice of his German investment manager, he'd invested in some risky call options which were traded in London. And those were acquired using money that Mr. Kronhofer had transferred into an investment account that he held in Germany. And the options ended up being liquidated on the London market and realising a loss. And the question that the court was being asked, as one sees at in the authorities bundle at page 206, paragraph 11 in the judgment, the question that was being asked was whether the place of a harmful event, in the case of pure financial damage, could be understood so as to discover the place where the claimant is domiciled and where his assets are concentrated by reason only of the fact that the claimant has suffered financial damage there. And the court rejected that proposition. They rejected it at paragraph 21. They said it wasn't sufficient just to say, well, I suffered the loss in my domicile because that's where my assets are concentrated. So that's the ratio of the case. The Court of Justice did not specifically address the question of where the damage did occur for the purpose of establishing jurisdiction if it wasn't Austria. Although at paragraph 17 of the judgment, you'll note that they refer without comment to the fact that the court below had held that the place that the damage occurred and the place of the event giving rise to it were both Germany. One notes, no one suggested in this case, as far as I can see, that the liquidation of the shares on the London market, liquidation of the options in the London market had any relevance to establishing jurisdiction. Now, one of the comments the judge made on this case, really by way of rejecting our submission that damage occurred in the place of investment, is she said, and this is paragraph 89 of her judgment, that no one suggested in Kronhofer that the place of damage was the place where Mr. Kronhofer placed his funds beyond control. And so she said that that's clearly not a relevant consideration. Now, it is true that it wasn't argued by Mr. Kronhofer that damage arose in the place where he put funds beyond his control in making the investment. But that was no doubt because on the facts, the place where he appears to have put his funds beyond his control was the investment account in Germany, and he was looking to establish jurisdiction in Austria. And indeed, Professor Briggs makes a point in his article that the outcome in Kronhofer can be explained precisely on the basis that Germany was the place where damage occurred, because Germany was the place where the funds were put beyond the investor's control in making the investments. And if I can just show your Lordship, that article is at tab 42 of the authorities bundle, page 1073.
It might not have suited Mr. Kronhofer to argue that, but it might have suited Mayer to argue that. So is the point that it's of interest that Mayer didn't argue it?
Well, of course, Mayer was domiciled in Germany, so Germany would have been a available jurisdiction anyway. So, so in truth, the point wouldn't really have arisen. But it is, I think it is still interesting to see what Professor Briggs says about this. It's at page 1077. And the middle paragraph on the page, it uses a reference to Kronhofer and Mayer. And what he says about 6 lines down, he says, the European Court did not suggest the loss might be seen as the earlier transmission of funds from the claimant's Austrian bank, observing without comment that analysis had not commended it to the referring court. Contention of the claimant that his loss occurred in Austria because that was where he was established was rejected. The judgment offers no clear guidance on the proposition that the loss occurred in Austria because it was from there that funds were pushed out onto a slippery slope. But it is to be inferred this was not the place where the loss occurred because, although at that point loss had come a step closer, the claimant could still have recalled his money, and it had not therefore been lost. Not until it was paid out of the German investment account was the money lost. So that's Professor Briggs' view, and again, it's worth noting that this was a case which in some ways has a similarity to the present case, that he was investing in a market instrument, and no doubt at the point he bought them, the value is what he paid for them. It's only because they were subsequently liquidated at a loss that he brought the claim. But nonetheless, the suggestion by Professor Briggs is consistent with our submission, I say, in looking to the place effectively where the investment was made. So that's Kronhofer. The next case is Kalasa. That's tab 21 of the authorities bundle. Mr. Kalasa, again domiciled in Austria. His complaint was that representations had been made in a prospectus for certain bearer bonds, which had been issued by Barclays. And the prospectus had been published in Austria. He bought the bearer bonds, and the bearer bonds were linked to the performance of an underlying investment portfolio, which was managed, again, by a German investment manager. And the problem in this case, and also in the Lober case, is that the bonds, essentially the investment manager put all the money into a pyramid scheme and lost it, as a result of which the bearer bonds effectively became worthless. Now, Mr. Kalasa says that he had purchased the bonds through a securities account, his own securities account at his own Austrian bank. And he therefore said that the damage occurred in Austria because the loss occurred directly in his bank account in Austria. And in that case, the Court of Justice accepted that as sufficient to establish jurisdiction under Article 5.3. And we can see that at paragraph 55 on page 509 of the authorities bundle, where the Court says, paragraph 55, the courts where the applicant is domiciled have jurisdiction on the basis of the place where the loss occurred to hear and determine such an action, in particular when that loss occurred itself directly in the applicant's bank account, held with the bank established within the area of jurisdiction of those courts. It's also worth noting, however, because it'll come up later, that another factor that the court found relevant under the damages limit is at the end of paragraph 56. They refer to the fact that the issuer of a certificate who does not comply with his legal obligations in respect to the prospectus must, when he decides to notify the prospectus relating to that certificate in other member states, anticipate that inadequately informed operators domiciled in those member states might invest in that certificate and suffer loss. So the fact that the certificate had been published in Austria was also a factor that the court held pointed to Austrian jurisdiction, because that's where the representation was made. And they seem to take that into account in their consideration of the damage limit. Now, in the present case, the judge, and this is paragraph 94 of her judgment, tried to distinguish Colassa because she said, well, this was a case where the investor had purchased something that was worthless at the very moment of purchase.
So paragraph, which of the judgment?
Paragraph 94 of the judgment.
I don't think that's right.
I got the wrong reference.
It is right. Thank you. Sorry, my fault. It is.
Right. So she said that was a. She said, well, it was effectively worthless, and she talks about something that was lower at the time of reliance. Now, one of the difficulties with these European cases is one doesn't get a very detailed description of the facts. But in my submission, that appears to be wrong on the facts, and the reference to that is the way it was described in the Lober case. Where what seems to have happened is that the shares were subscribed to, so investors subscribed to these certificates, and then the money was used by the managers to put into investments. So it appears actually that, if we just turn it up, it's tab 28, 718, in the Lober case, which was on the same facts. You see in paragraph 8 and 9 of the Advocate General's description, he refers, he or she refers to the fact that there was a public offer to subscribe to the certificate. And then in 9 it says the amount repaid was governed by an index made up of a portfolio. The portfolio concerned was to be established and administered by X1 fund. Since the money invested in the certificates was used in a pyramid fraud scheme, and has for the most part been lost, the certificates have become worthless. So, I mean, as far as one can tell from that description, it appears that this was an investment where one puts money in by subscribing to the certificate, and the manager then invests it. And what actually happened is that the manager then lost it by putting it into a pyramid scheme. So in that sense, that they only became worthless because of some subsequent crystallising event. And in my submission, the judge is not, face of it, right to say that the certificates were, that the case can be distinguished because it's a case where what was bought was that worthless from the outset. But in any case, I would add this. The fact that the judge had to distinguish Colassa in that way by looking at the timing of the fraud, in my submission reveals an unsatisfactory feature of her approach. Because it can't be right in my submission that the jurisdiction available to the investors under Article 5.3 depends, or would have depended on that case, on whether the fraud occurred before or after the investors had acquired the certificate. In other words, whether they had a loss from the outset or whether it was crystallised by something that happened later. And that, in my submission, illustrates a difficulty with the crystallisation approach. It results in different answers depending on the occurrence of the event that makes the investment worthless. So that's Colassa, and that's one of the two cases where the court did accept jurisdiction, and they accepted it on the basis that the applicant had invested through his account in Austria. Then we get to Universal Music, which is at tab 23, which is a case on which the claimant and the judge put a lot of emphasis. Now, it's important to note that...
is Universal Music the latest European Court decision on similar facts? No.
No, VEB is the latest case.
VEB.
And I would also say that universal music is not on similar facts for reasons I'll come to remember. But it is the... I'm sorry, I should... The LOBA is also after universal music.
LOBA's after.
LOBA. So it's universal music, LOBA, and then VEB. Now, universal music was not an investment case, and it was not a misrepresentation case. What had happened is that universal music had acquired an option to buy shares in a Czech company. But because of the negligence of their Czech lawyers in drafting the option agreement, they ended up committing to paying a much higher price for the shares than they'd ever intended to. But the precise amount of the price, the working out of the formula in the agreement, was fixed by a subsequent compromise agreement. And both the original option agreement and the compromise agreement were made in the Czech Republic. And Universal Music argued, relying on Kalasa, that it was sufficient for them to establish jurisdiction in the Netherlands. It was sufficient that they paid the settlement out of their Dutch bank account. They said that was enough. And that argument was rejected by the court. One sees that at paragraph 40 in the judgment, at page 568 of the authority bundle. They say the answer to the question is that Article 5.3 must be interpreted as meaning that in a situation such as that in the main proceedings, the place where the harmful event occurred may not be construed as being, failing any other connecting factors, the place in a member state where the damage occurred, when that damage consists exclusively of financial damage, which materialises directly in the bank account of the applicant, and is a direct result of an unlawful act committed in another member state. So one needs to read that quite carefully. It appears that the court is not disputing that Universal Music had suffered damage in the Netherlands. It refers to damage there. What they seem to be saying is that damage of that kind was not sufficient to establish jurisdiction in the Netherlands unless there were other connecting factors. And that, in my submission, is the ratio of this case. It's saying that merely paying money out of a bank account, if there are no other connecting factors, is not sufficient to establish jurisdiction. Now, the court did go on to say something about where the damage, or the relevant damage, had actually occurred. And they dealt with that in paragraphs 29 to 32 on page 567. And again, perhaps I could just ask you just to remind yourself of the contents of those paragraphs.
Sorry, I've lost my reference.
It's page 5, tab 23 of the bundle, 567 page, paragraphs 29 through 32. Now, the judge said, judge below said at, the reference is paragraph 98 of her judgment, that what this showed was that, and I use her words, that the location where damage manifests is identified from some objectively ascertainable step or act which crystallises the loss and connects the two parties together. And that's the way she formulated the position in paragraph 98. That, however, with respect, was not what the court was saying here, either expressly or by implication. What they were doing in paragraphs 29 to 32 was identifying what they saw as two important connecting factors between the damage that was claimed and the Czech Republic. And they were doing that for the purpose of rejecting the argument that payment from a Dutch bank account was itself sufficient to establish jurisdiction in the Netherlands. Now, what they did not do in these paragraphs, because they did not need to, is to go on to consider whether, if the question had been whether jurisdiction was established in the Czech Republic, would those two factors, either together or separately, or just one of them, and if so, which one of them, would those factors have been sufficient to engage Article 5.3 in respect of a claim to jurisdiction in the Czech Republic? So they didn't do that. They didn't need to do that because, of course, again, Universal Music was not arguing for Czech jurisdiction.
So, Mr. Quest, can I put this to you?
Yeah.
If you look at paragraphs 38 to 40
Yeah.
of this judgment,
Yeah.
they do draw conclusions as to why purely financial damage which occurs directly in an applicant's bank account cannot be qualified as a relevant connecting factor under 5.3.
Yes.
And say that it's anywhere other circumstances specific to the case also contribute to attributing jurisdiction.
Yes.
That financial damage can give rise to jurisdiction under 5.3. Why, by analogy, is it not the same in this case, where the financial loss is felt
Yes.
in London when the shares are sold, but that by itself is not sufficient? But the fact that UBS's conduct in selling the shares and exercising its rights under 7.7 of the facility agreement, etc., all takes place in London, are other connecting factors which allow a jurisdiction to found in London in a case of this kind, by analogy with UMI.
But can I come back to that question, if I may, after we've looked at LOBA, where there is a discussion of what the connecting factors might be? I understand your question, which is that should the fact that the secured account and the shares were held in London, is that a relevant connecting factor?
No, I didn't say that. I said they were. I said under the facility agreement, everything happens in London. It's an English agreement, English law, English jurisdiction, and UBS London acts under those agreements in London to give rise to the loss which is felt in London. So the fact that all that precedes the loss being felt in London is analogous with what is being said in these paragraphs.
There's an important distinction.
About Czech.
Yes, but there's an important distinction here, though, which is those agreements that your Lordship referred to had nothing to do with Ace Decade. Ace Decade was not party to those agreements.
Well, that's, if I may respectfully say so, rather a technical approach. I mean, the whole transaction is a single transaction intended to allow S Decade and Mr. Kwok to invest in these shares.
Well,
indirectly.
With respect, I wouldn't put it as a technical distinction. As I said before, this investment was specifically structured so that Ace Decade's right would only be under the investment contract.
Technically.
Well, your Lordship, when I attached the label technical.
But this is about money, Mr. Quest. Mr. Kwok invested $500 million of his own money in this transaction, structured in a way, quite properly, as you say, to give him some protection from no doubt tax arrangements somewhere. And you're right. I mean, nobody doubts you're right. But I come back to the same point. We're looking, and these authorities are telling us, aren't they, to look at substance.
But they're not saying that one can entirely depart from the principles that apply to jurisdiction and just look for connecting factors. The convention could have been drafted in such a way as to say, well, one can bring a claim in any jurisdiction that has some connection with the dispute. One could have a jurisdictional arrangement like that, and if that were the case, one could adopt a very broad brush and simply look at the matter in the round and say, well, what factual connections are there? But that's not what the convention provides, and it's not the way the Court of Justice looks at it in UMI either. They don't say, well, stand back from this. This is really all about the Czech Republic. They say, well, there are two particular contracts which UMI was a party to, which it entered into in the Czech Republic, namely the settlement agreement and the option agreement. And the fact that UMI had entered into those arrangements in the Czech Republic was something that the court felt was an indicator as to where the damage occurred. So in my respectful submission, one can't, it would be wrong in principle just to take the approach that one has to just look at the substance. If what one means by that is, the non-legal substance, the overall fact, one was trying to apply a particular rule, which the court tells us we must apply restrictively, and which is a derogation from the overriding rule, which is that parties should be sued in their place of domicile. And the point I make on UMI is that those I think that the reliance that was placed on it by the judge and indeed by the claimant was not to say, well, this is a case which shows one can look generally at all the factors, but to say that this case was in some way support for the crystallisation argument, because at paragraph 31, the court referred to the fact that the settlement agreement was what had rendered the loss certain. But in my submission, the court was not saying that that was the benchmark to be applied to establishing jurisdiction, and it didn't have to do that because it wasn't concerned with the question of whether there was jurisdiction in the Czech Republic. There was obviously jurisdiction in the Czech Republic, not least because the relevant defendant was domiciled there. They were identifying those. Matters not for the purpose of establishing Czech jurisdiction, but for the purpose of refuting Universal Music's argument that it was sufficient for them to come to the court and say the fact that we paid this settlement out of our Dutch bank account is itself enough for the court to establish jurisdiction, and that's the point that they rejected in that case. And as I say, in my submission, they rejected it on the basis that that wasn't sufficient damage. Without embarking on, or without suggesting that one can look at the matter much more widely and take all facts into consideration. And I mean, indeed, if one looks at the way it's put in paragraph 30, when the court talks about the entering into the agreement, it would have been a strange conclusion for the court, if it had reached it, to say that no damage occurred until the final compromise agreement had been reached, because it's clear from what they said at paragraph 30 that Universal Music suffered direct manifested damage when it executed the option agreement, which contained terms that it didn't intend to bind itself to. And indeed, there seems no reason why Universal Music couldn't have commenced proceedings against their lawyers as soon as they discovered the problem with the agreement, without necessarily waiting for a final quantification of the cost of the problem through the compromise. They would have been entitled to say to their lawyers, well, you've messed up this agreement. It looks like we're going to have to pay more than we expected. We don't know how much that is, but we're entitled to bring proceedings against you now because damage has occurred. Where's it occurred? It's occurred in the place where we entered into the agreement.
And you say it's not a material distinction, that there it was, as it were, obvious, inevitable, that there would be damage yet to be precisely quantified, but not necessarily obvious or inevitable on the facts here.
I mean, damage, I suppose, is never inevitable.
In terms of the share price going down.
I mean, I can see it might be said here. It was more obvious or more inevitable.
Yes.
But in every case where someone has entered into an obligation
Yes.
on terms or with features that they did not want to enter into, they can say, well, there is a possibility of loss.
So the answer to my question is, you say no material distinction, qualitative distinction, but no substantive distinction.
I should also just show you what Professor Hartley says about this, because again, the judge relied on this article, in my respectful submission, wrongly. It's at tab 44 of the second authoritative bundle, as supporting her, if I can put it this way, her crystallisation theory. And Professor Hartley, it's page 1104. Professor Hartley...
Sorry, could I have the tab number?
Oh, it's tab 44.
Thank you.
Page 1104, which deals with the Universal Music case. And what Professor Hartley says at the bottom, the paragraph at the bottom of the page, he says, this case shows the inherent ambiguity of the concept place where the damage occurred. On a strict application of legal principle, it might seem equally plausible to say the damage occurred where the contract was concluded, where the settlement was agreed, in the bank account from which the payment was made and in the bank account to which the payment was made. However, a rule based on the conclusion of the contract, brackets and settlement, would probably be less open to manipulation than one based on the mechanism by which the payment was made. Now, there are obviously sort of different options one can go for there, but none of them suggest that crystallisation is a benchmark. And when we come to look again at the facts of this case, I'll be suggesting that none of those matters that Professor Hartley identified as possible routes to jurisdiction or localisation of the damage would apply in the present case. The next case, fourth case, is Lober, and that's at tab 28. That's essentially on the same facts as Classic. It was the same investment scheme. And here, if we go to paragraph 30 of the judgment, we see that the Court of Justice slightly qualified their decision in Kalasa, in as much as they said that the fact that the loss occurred directly in Mrs. Lober's account in Austria wasn't by itself sufficient to establish Austria as a place of occurrence of the damage. But it was necessary to, and actually that's but that it was necessary, as had been said in Universal Music, to identify special connecting factors as well. And then they go on to say in paragraph 31, so paragraph 30, they say, Article 5.3 must be interpreted as meaning that the place where the harmful event occurred may not be construed as being failing any other connecting factors, place in a member state where the damage occurred. And then in 31, they go on to consider what special factors there were. And it's worth identifying what factors, and this obviously is an investment case, the court thought was relevant. First of all, in 32, they refer to the fact that all the payments in relation to the investment transaction at issue were made from Austrian bank accounts. And then in 33, they say that Miss Lober had dealings only with Austrian banks. And they say it's furthermore apparent from the order for reference, she acquired the certificates on the Austrian secondary market. The information supplied to her concerning those certificates is that the prospectus which relates to them as notified to the Austrian supervisory bank. And then on the basis of that information, she signed in Austria the contract obliging her to make the investment, which has resulted in a definitive reduction in her assets. So one sees the factors the court applies. It's where did she pay the money from? Where was her account? Where did she sign the agreement? Where did she reasonably act on the representation? And what's notably absent from this discussion is anything about Germany, even though the underlying funds were held in Germany and had been lost, and therefore, in one view, loss caused as a result of the depredations of the German investment manager.
But I thought you told me that when we got to Lober, we'd see that the connecting factors I suggested to you would not be relevant. And I don't understand why, in the different facts of this case, the connecting factors of the London security, the London agreement, the London jurisdiction, the London law, the London enforcement is not a connecting factor in the different circumstances of the case.
Because all of those matters are matters that go to the relationship between UBS and Dawn State, and none of them concern Ace Decade. So to run through the labour factors,
they concern, just to so you get the point, they concern the loss that Ace Decade claims in respect of. I quite understand that the loss, you may have a complete defence based upon the fact that it's a relationship with Dawn State, but it does concern the loss that Ace Decade is claiming, even if you may say it won't succeed.
Well, it's if I can say, it's part of the story that leads up to the loss being made. It's one of a sequence of events that results in the loss being made. But if one looks at the factors that the court identifies here, these are all factors about what the claimant, what Miss Lober, the alleged victim of the representation, had done. She had an account with the Austrian bank account. Ace Decade does not have an account in England. She paid the money in Austria. Ace Decade did not pay any money in England. She entered into the investment contract in Austria. Ace Decade entered into the investment contract in China. She was dealing with something that was traded on the Austrian market. Ace Decade was dealing with something that was traded on the Hong Kong markets. So when one looks at the equivalent factors that the court here thought were relevant to Austria, those, and in my submission, logically, are all concerned with, and sorry, I should have added to that list also, they considered it important that she had acted on the basis of a representation that would be published or made to her in Austria because he'd been notified to the Austrian Supervisory Bank. So those are all factors that translate to, if one translates to our case, point to China or Hong Kong or anyway not England. I mean, perhaps I might just at this point, just to perhaps follow up on the Master of the Rolls point, because the judge made, in a way, a similar point at paragraph 76 of her judgment.
Are we going to look further at Lober, or have you finished with Lober?
I have finished with Lober. And sorry, paragraph 116 of her judgment.
Sorry, not 76.
No, sorry, 116, page 98. Sorry, 118. I'm so sorry, 118, where she says, finally looking to the special circumstances. So this was the judge's attempt to identify special connecting factors with London, presumably along the lines of those identified in Lober. And she identified as the connecting factors the secured account in London, which was the place at which it had been agreed by all parties that the acquired shares would be held. And all of the contractual documents that UBS entered into, albeit for a transaction at one remove from the claimants, were to be in English and governed by English law. But as I said before, those are all matters that relate to Dawn State. The secured account was Dawn State's account. Ace Decade didn't have an account with UBS, and it hadn't entered into any agreement with it. And this analysis only really works by effectively merging the positions of Ace Decade and Dawn State and treating them as being the same party. So that one could look to things that Dawn State did in London and say, well, that's a connecting factor for Ace Decade. And that, in my submission, will be wrong in principle, because they're different claims, they're different parties. And the jurisdictional test has to be satisfied by Ace Decade by reference to its own claim, and its own positions, and the contracts that it entered into. The final European case is the case of VEB and BP, which is at tab 31 in the authorities bundle. In this case, the claimants were in the Netherlands, and they said that in reliance on non-disclosures or misrepresentations by BP, they purchased shares in BP. And they purchased them through Netherlands banks or Netherlands investment firms. And those shares then fell in value as a result of the Deepwater Horizon rig explosion. And the claimants again argued, again by reference to Lober and Kalassa, that the damage occurred in the Netherlands because that's where they bought the shares. Now, the Court of Justice distinguished Lober and Kalassa on a rather particular ground, which one sees at paragraph 18 of the judgment, on page 811 of the bundle. So 17 refers to Cobra and Kalassa. And then at 18, the refers to the fact that the referring court considers those facts differ. The facts in the present case differ, in that the financial loss at issue in the main proceedings was caused by BP's disclosure of incorrect, incomplete and misleading information by means of press releases, reports published on its website.
Sorry, what page are we on?
Page 811. Paragraph 8.
My fault, thank you.
So what was said to distinguish Lover was that the representations had been published globally on the website and so on, and not, as in the first two cases, that's Calassa and Lover, by the disclosure of such information in the territory of a particular member state. Additionally, the referring court takes the view that BP, when providing that information, did not separately or specifically approach Dutch investors. And that was essentially the ground on which the court distinguished Lover and Calassa. And it was, if one goes to paragraph 35, one sees their conclusion on page 815. They say it follows in the case of a listed company, such as that in issue in the main proceeding. Only the jurisdiction of the courts of the member states in which that company has complied for the purpose of its listing on the stock exchange with the statutory reporting obligation can be established on the basis of the place where the damage occurred. It's only in those member states that such a company can reasonably foresee the existence of an investment market and to incur liability. Now the logic, I must say, is not entirely easy to follow, because it appears to be concerned not so much with where the damage in fact occurred, but more to do with where it was foreseeable that it might have occurred, in the sense of where it was foreseeable that people might have invested. And in my submission, this case might be best understood as, in effect, qualifying the damage limb of Article 5.3 by restricting it to places where the harmful event had foreseeably given rise to damage, because that seems to be what they're saying here. Or alternatively, it might be regarded as a special rule, perhaps, for cases based on statutory non-disclosures by listed companies. The special rule being that companies of that kind can only be sued where they're listed.
Well, would it not be foreseeable here that damage would occur in London?
Not to Ace Decade, no, because Ace Decade's involvement in the investment was only by way of contractual rights and obligations that it had entered into in China. So the point that was being made in this case is that they may have paid out money in the Netherlands, but in some way it wasn't foreseeable that they would have done that, because the representations were made in Germany, and therefore Germany should be the place of jurisdiction. But I mean, however one reads it, it doesn't, in my submission, provide any support for the suggestion that one should localise the damage in the place of the crystallising event. I mean, if the rule that emerges from VEB is that one looks to the place of listing, well, the place of listing here was Hong Kong. That's where the Haitong shares were listed. One looks to the place where the representation was reasonably relied on. That's also Hong Kong. And nothing in this case supports the view that one looks to the event that crystallised the loss. And that's actually obvious from the facts of this case, because this case very clearly is a case where there was an identifiable subsequent contingency which had the effect of bringing the share price down, that being the Deepwater Horizon explosion. It was that, obviously, that caused the BP shares to fall, and that's what the VB claimants were ultimately claiming in terms of measuring their loss. But I mean, it's no one suggested in this case that the damage that was caused to the investors in this case should be localised in the Gulf of Mexico or in the United States, because that's where the event occurred which crystallised or ascertained the fall in the share price. Again, the court was not focused on crystallisation, but on what the investors had done by way of investment. So I said I would draw some conclusions from these European cases, and there are really two main ones. I mentioned them before, but the first one is that none of these cases supports an analysis, which was a judge's analysis, that jurisdiction can be established in the place of a subsequent event crystallising the loss, rather than in the place where the investment is made. And none of the cases refer to that kind of crystallisation analysis, even where, as in VEB, it is actually possible quite easily to identify a crystallising event, in that case, the rig explosion. And it's not surprising in our submission that that's not the approach adopted by the courts, because there are a number of difficulties that the crystallisation analysis creates. Some of them are identified in our skeleton, I won't repeat them, but just to highlight three. In real life, there may be a number of different events in different places, which separately or in combination come together to cause the loss. And in one sense, that's the case here. I mean, the judge obviously focused on the sale of the shares as being the cause of the loss, which happened in London. But looking at it more broadly, I mean, that was itself the consequence of what had happened in China as a result of the crash in the Chinese stock market. And that was the sort of fons et origo of the loss here, what happened in China. Second point, crystallization. If one looks to crystallization events, one might be looking at find a location which has no connection with either party, which is unpredictable. And again, if one thinks about VEB, if crystallization was the right answer, I mean, BP's presumably got drilling rigs all around the world, some in the EU, some not. The failure of any one of which might crystallize a loss in an investment in BP. But it would be odd in my submission if the jurisdiction changed depending on the underlying event which gave rise to the loss, or the ascertainment of the loss. And the third reason we say crystallization is not appropriate is because in principle, a claimant doesn't need to wait for his loss to crystallize or to become ascertained before bringing a claim. One can, in principle, bring a claim for a future unascertained loss. And going back to a point I made again this morning in answer to the question from the Master of the Rolls, in principle, if Ace Decade had discovered the misrepresentation before the share sale occurred, it could, in principle, have brought a claim there and then. It didn't have to wait for the shares to be sold. And of course, the share price had already dropped before the sale occurred. So nothing supports the judge's view. And the second conclusion I draw from these is that it's notable that the only cases in which the CJU has permitted jurisdiction is Colassa and Lober. Those are the only two cases in which jurisdiction has been established. And I've already identified to your lordship and to your ladyships the factors which led the court to accept jurisdiction in those cases, none of which are present in the present case. Now, there may be other cases in which, I think there were 4 factors in Lober, there may be other cases in which one might debate whether just some of those factors would have been sufficient by themselves. But the court doesn't need to resolve that because, as I say, in this case, in our submission, there are no relevant factors of the kind that the court identified that point to England. Ace Decade didn't have an account here, didn't receive the representation here, didn't sign the contract here, shares were listed in Hong Kong. It didn't have anything to do with. So those are the European cases. I'll just deal much more briefly, if I may, with the English cases, because most of them actually predate the European jurisprudence, and so they obviously have to be read in light of that. But they are consistent with that. And I just want to highlight just one case, actually, in view of the time, which is really to answer a point that the judge made in paragraph 80 of her judgment. She said, and she went through the English cases that we cited to her, all of which look to essentially to the place of the investment or the commitment. But she said at paragraph 80 of her judgment that there was little assistance to be gained from the English cases because they were all essentially cases of a non-contingent loss crystallising on the entering into of an agreement. In other words, it's her point that these were cases where undoubtedly there was some ascertained or crystallised loss at the very moment of investment.
And you said that was the case here?
Well, so I say two things. I say, one, that was the case here, but also that's actually not a correct reading of the English authority. And that comes most clearly from the Domicrest case, which is at tab 7 of the authorities bundle.
Mr. Justice Ricks.
It's Justice Ricks. What has happened here is the plaintiff was complaining that he had released goods to his foreign buyer in reliance on a representation by the bank, the defendant bank, that a payment order that the bank had issued effectively amounted to a guarantee. So he'd been represented to him that the sale was guaranteed by the bank. He released the goods, and then he suffered loss because the buyer didn't pay for them. There was no counterpayment. And the plaintiff in that case argued that he didn't suffer the loss when the goods were released, because they might have been paid for. He only suffered the loss when and where the buyer failed to pay for them in due course. And that argument was rejected by Mr. Justice Ricks. If one turns to page 568 of the judgment, 134 of the transcript, 134 of the bundle.
Sorry, 134.
134 of the bundle, 568 of the report. He says, letter D, as for the place where the damage itself occurs, that may of course be elsewhere than the place of the event giving rise to the damage. And as I've already suggested, it's quite likely to be where the misstatement is heard and relied on. But in this case, I do not think that it was in England. In my judgment, Mr. Dunning is right to submit that the damage occurred in Switzerland and Italy, where the goods were released without prior payment. It's by reference to the loss of those goods that the damages are, in my view, primarily pleaded, even if there is also an alternative plea in subparagraph 3 in terms of the unpaid price. In truth, even though Domicrest would have suffered no loss if Swiss Bank Corporation or Interglobal, which was the buyer, had paid the price of those goods, nevertheless, it has to be remembered that the remedy in negligent misstatement is not as it is in contract, to be put in the same position as if the contract had been performed. It depends on the answer to the question, what would have happened if the negligent misstatement had not been made? In that case, the goods would not have been released before payment, and thus lost to Domicrest. The essence of the complaint is, in any event, that the goods were released prior to payment on the strength of the representations. It seems to me that's consistent with the decision in Marinari. And in my submission, that's analogous to the position here. The essence of the complaint is that that Ace Decade would not have entered into this investment representations, and as a result of entering into it, he was exposed to the possibility that UBS London might foreclose. Of course, if the shares had remained above the strike price, then it may be said he wouldn't have suffered a loss in the value of the shares. But exactly the same point arose in...
But Domicrest wasn't referred to by the judge.
No,
she wasn't referring to Domicrest in paragraph 8.
No, she wasn't. And I think, to be fair, although that case was mentioned, I think, in our authorities, I don't think it was raised specifically in oral argument. So it's not a criticism of the judge not referring to it. But her reasons for not following the line of English cases, which, as she sets out in her judgment, refer to really the point at which the investment was made, in my submission, is not a sound reason from departing from them. And in addition, in a sense, it doesn't matter. I mean, more importantly, the judge's approach just doesn't take account of the fact that a person who enters into an investment and pays out money, parts with the money, for something which was not as it was represented, as Domicrest shows, by that fact is damaged by having made the investment. If he hasn't got what he wanted, paid for something he hasn't got what he wanted, even if there's a possibility that he might end up getting his money back. So we say that they're difficult, some of them, to read, but the better view of all of the authorities read together is that in an investment misrepresentation case, damage should be treated as occurring for the purpose of Section 5.3 in the place where the claimant makes the investment in reliance on the representation, either by entering into the agreement or by committing funds to it. That distinction not being relevant on the present case. So that's what we say the true rule is. That said, of course, the disposal of this appeal doesn't require the court to lay down a definitive and comprehensive rule for every case in which Article 5.3 might be engaged, but only to decide whether it's engaged on the facts of this case. And in that respect, we say the authorities do not support the judge's approach. That was really all in relation to ground 1. Ground 2, which is to do with the application of the test, I can deal with much more briefly. Clearly, if we are right on our position under ground 1, that the judge should have looked to where the investment was made rather than to where the shares were sold, then if that's the right test, there's clearly no basis for jurisdiction because the investment was made by Ace Decade in China. We do, however, also say that even if the judge was right to say that the damage only occurred when the shares were sold by UBS in London, we would still say that the location of that damage, or the location of the damage caused by that sale, was not England, but was China or somewhere else. That is to say, the fact that the sale of the shares took place in England, even if that's regarded as the cause of the damage, doesn't mean that the damage occurred in England. And I say that because, however one looks at this case, the ultimate point, the critical point in our submission, is that the only rights or assets that Ace Decade ever acquired in connection with this investment was its contractual right under the co-investment agreement with Hyxia to share in distributions from Dawn State and an option to acquire the shares. So the only obligations and payments it ever had were obligations and payments under that Chinese agreement. And so it follows in our submission that if Ace Decade has been directly damaged in any way and at any time as a result of making this investment, that damage necessarily arises out of the transactions under the co-investment agreement and the rights and obligations assumed under that agreement. And that was an agreement made in China, performed in China. And so we say whatever test the court applies, whether it's our test or whether it's a judge's test, damage can't be localised in England. And AD, that's what I propose to say on the Article 5.3 point. And I now move to Article 5.5. I'm going to endeavour to finish by, I think, 1/2 past to allow Mr.
Yes, well, it's a shorter point.
It is a shorter point, yes. In some ways, it's a very short point.
Yes.
If we might just start just by reminding ourselves of the terms of the provision. You can take it from paragraph 120 of the judgment below, page 99. It refers to dispute arising out of the operations of a branch, agency, or other establishment in the court of the place in which the branch, agency, or other establishment is situated. Now, if one had no guidance from authority, one might take the view, just reading those words, particularly the words dispute arising out of the operations of a branch, one might take the view that has a broad interpretation and that it will be sufficient for the claimant to establish some kind of factual connection between the operations of the branch and the dispute. In our submission, though, it's clear from the Fly LAL case, which we'll look at in a moment, that Article 5.5 cannot be understood, should not be understood in such an expansive way. That case is at tab 29 of the authorities bundle. What had happened in that case is that Fly LAL, which was a Lithuanian airline, had sued Air Baltic for competition law breaches. And in particular, there was an allegation that Air Baltic had engaged in predatory pricing in breach of Article 102 of the treaty in respect of flights that it sold between Lithuania and Latvia. And Fly LAL, the disappointed Lithuanian airline, sued Air Baltic's branch in Lithuania. And what the court said, we see in paragraph 63 of the judgment on page 707.
Sorry, did you say 787?
707 of the report, 760 of the bundle. And this section begins at paragraph 58, considering seeking guidance from the court about the interpretation of this provision. And the court says, 63, as observed by Advocate General Bobek, in the case of actions based on tortious liability, in order for the dispute to be regarded as arising out of the operations of a branch, that branch must have actually participated in some of the actions constituting the tort. I'll just come back to 64 in a moment, but then at 66 they say, in their final conclusion they say, in the light of those considerations, the answer to the third question is that Article 5.5 must be interpreted as meaning that the notion of a dispute arising out of the operations of a branch covers an action seeking compensation for damage allegedly caused by abuse of a dominant position, consisting of the application of predatory pricing, when a branch of the undertaking which holds a dominant position actually and significantly participated in that abusive practice. So the test is actual and significant participation in the actions constituting the tort. Now, the court, in this case, didn't actually decide whether that was made out on the particular facts. And what they did, and you see this in paragraph 64, is they essentially remitted the question to the referring court to identify the potential role of the Air Baltic branch in the commission of the anti-competitive conduct alleged. In view of the information contained in the order of reference, it should examine in particular whether the activities carried out by that branch included actual acts of offering and applying the predatory pricing alleged, and whether such participation in the alleged abuse or a dominant position was sufficiently significant to be regarded as a close link with the dispute in the main proceedings. So that was the way the Court of Justice put it. In our submission, the judge failed to follow that approach. And one can see that if one goes to her judgment at paragraph 140 of the judgment, 101 of 4 bundle. So having set out at some length the relevant passages in Fly LAL that I've just read to you, she says at paragraph 140, for the avoidance of doubt, I do not regard the authorities as justifying the submission that sufficiently significant connection requires involvement in the tortious acts. This is nowhere stated in the authorities and would appear to equate to the standing in approach. Well, certainly on my reading of that respectfully seems to be directly contradictory to what the Court of Justice had said in paragraph 63 and 66, where they had said in terms that it was necessary for the branch actually to participate in the actions constituting the tort. So with respect to the learned judge, it's hard to see how the first sentence of paragraph 140 can stand with Fly LAL. And then she went on to say at the end of 140, the last sentence, she says, indeed the opposite is demonstrated by the facts of Fly LAL, in that it appears clear that the CJEU's view was that the branch rule was engaged so long as it had unwittingly offered the predatory prices set elsewhere without any involvement on its part. And again, in my respectful position, one can't extract that at all from the case. The CJEU had not made any findings about what the branch had actually done. And what they'd asked the referring court to do is to go back and examine, this is paragraph 64, whether the branch included actual acts of offering and applying predatory pricing, and whether that participation was sufficiently significant. So the suggestion, which might be what the judge is trying to get at, that in some way innocent participation or unwitting participation would be enough, is not, in my submission, something that one can get from the Fly LAR case. Indeed, it's contradicted by that. She then, again with respect, kind of compounds that error by what she says in paragraph 141, because she then goes on to ask herself the question, does the claim arise out of the operations of the branch? In other words, she asks herself, I mean, that of course is the wording of the convention, but if one asks it, as it were, literally, one gives it a more expansive, or potentially one gives it a more expansive meaning than the Court of Justice said that it bears in Fly LAL. So in my submission, the question she asked at 141 was the wrong question. She should have been asking, does the claim, she should have been asking whether, as the Court of Justice said, the branch had participated, had actually participated in the actions constituting the tort. And one can see that she's, as it were, followed the wrong path, because having asked the question in that way, she says, well, to this the natural answer is yes. Though it arises out of the operations of another branch also, the claim could not occur, nor the story be told, without including UBS London in the narrative. Similarly, if one asks a question by reference to the criterion of sufficient nexus, I conclude there is sufficient nexus. And then she goes on at 142 to talk about UBS being a part of the deal structure. It was there from the outset. It was UBS London's policies that were the subject of the misstatements. The claim relies in a disconnect between what was said and so on. All of which, in my submission, show that what she was doing is looking simply at whether there was a sufficient factual connection between the facts giving rise to dispute and the actions of the London branch, rather than, as she should have been, asking whether the London branch actually participated in the tort.
Can I ask you this? Assuming you're right and she's wrong, and it's not just sufficient nexus that you're looking for, but you're looking for participation in the tort, and assuming that I'm right and you're wrong about the importance of the sale of the shares as giving rise to loss, irrespective of the 5-3 argument, but that even if loss occurred at the point of entering into the agreement, it also occurred in London when the sale shares were sold, right?
Yes.
Assuming those two things, why is the sale of the shares not part of the participation in the actions constituting the tort?
Well, I think one can say, at least, and even if Lordship takes the point against me on damage, that the sale of the shares was not a tortious act, in the sense that it wasn't a breach of any duty that UBS London owed to Ace Decade. Ace Decade is not saying that there was anything wrong about that.
But why didn't it constitute damage, which the tort is only complete under English law anyway, when it happens?
Well, that would, first of all, that would, in my submission, be to take a too domestic a view of how one looks at it. I'll come to what Fly LAL says in a minute. The point really is this. I mean, the fact that UBS London did something, or that had the effect of crystallising the loss, does not mean, in my submission, that it can be said that it's participated in a tortious action or participated in an action constituting the tort. Yes, that's an event which is part of the story and gives rise to the calculation of the damage, but it's not part of the act constituting the tort of negligent misstatement. And if one thinks about what negligent misstatement is as a tort, it involves, as it were, things on the claimant side and things on the defendant side. On the defendant side, there's got to be an assumption of responsibility, there's got to be a misstatement, there's got to be negligence, and then and those are all actions that have to be established as against the defendant. And then on the claimant side, the claimant has to show reliance and that he suffered loss as a result. But the fact that the branch may have done something which is part of the chain of events that leads to the ascertainment of the loss, that doesn't, in my submission, mean that it's involved in the tort, in the sense that it's participated in actions constituting tort. And one can perhaps test the point in this way. I mean, in this case, it so happens that another branch of UBS was the financing bank. But supposing the facts had been different, and a different London bank had done the financing, and the facts had otherwise been the same, and the representations had been made about the policy of that bank. The bank had sold the shares, and the claim had been brought in exactly the same way. If it were a different entity, it would, in my submission, be rather surprising if it was said that that bank, to use the my LEL wording, was participated in acts constituting the tort of negligent misstatement when it had nothing at all to do with that. And in my submission, there can't be any difference if one's looking UBS London as regards a different bank. I think it's worth, and obviously we don't have any authority beyond Fly LAL itself to explain further what's meant by participation in actions constituting tort. But there is, in my sense, when one looks at what they said about the nature of the investigations that needed to be made in order to establish Air Baltic's, the Lithuanian branch's participation in the actions, there is a strong inference that the branch has to have participated in conduct that can itself be regarded as somewhere as tortious.
Yeah, but that's because of 64.
Exactly, because of 64. And I mean, if what the CJEU had in mind is that it was enough that the branch was factually involved in the chain of events that led to the loss, then in a sense they wouldn't have needed to interpret Article 5.5 in the restrictive way they did. They could just have left the wording as it was. They could have said, well, all you need to do is to say, well, does it arise out of the operations of the branch? And that can be satisfied if there's a sufficient factual connection. But they went out of their way to, as it were, read that down to actual participation and significant participation in the actions constituting the tort. And in paragraph 66, they refer to actual and significant participation in the abusive practice.
And so, were the actions that constituted the tort the agreement to reduce the fees at Riga Airport? In that case, is that? I'm just trying to relate it to the facts in my mind.
As I understand it, I think there were two different complaints. One is that there was an agreement, and then that, as a result of that agreement, they embarked on a process of predatory pricing.
Pricing, yes.
Yeah, so there were two.
So two elements of it.
Two elements, and I think the branch's involvement, because it wasn't suggested that the Lithuanian branch had been involved in the making of the agreement.
No.
What was suggested is that they were, or at least what the court said might be sufficient, is if they were involved in the process of the predatory pricing.
Beyond simply taking action at the direction of headquarters, as it were. I mean, I think the facts matter in this case, and I'm just not entirely clear what the court was linking those sentences to in the facts that are set out earlier in the judgment.
Well, I'm not sure, I'm afraid, that I can tell you any more about the facts. I mean, one perhaps point is that it does refer back to 142 of the Advocate General's opinion.
Okay, let's have
And the Advocate General refers to, you said you have paragraph 142, page 747 of the bundle, he says the branch can still be considered to have participated in the predatory pricing, even if it's not fixed predatory prices itself, but would have offered those prices on the market, or otherwise been instrumental in concluding contracts for services in those prices. In such a case, the branch again participated in the commission of an act which constitutes a necessary precondition for the abuse. I don't know if that helps, but that seems to be all the information we've got. And of course, I mean, this was a case where, like many of them, where the court was not accepting the jurisdiction, and therefore didn't have to reach a final view, I suppose, on the facts of that case.
Is it justified in saying that the Court of Justice read down the words of the Article 5.5 when they concluded that the answer to the third question was that Article 5.5 must be interpreted as meaning that the notion of a dispute arising out of the operations of a branch covers an action for compensation, etc.? Is it not just saying, in this case, this will be the question?
Well, in my submission, no, because what the test there appear to be setting is a narrower test than one might otherwise read the language as, and there wouldn't really be.
Why not? Because of the circumstances of that particular case, where you were looking at the tort, the elements of where the tort had been committed.
Why, in a sense, should it be any different from any other tort?
Well, it's a bit. I mean, I'm just speculating, but it may be a bit different in our case, where you have loss, which you describe as the conduct that gives rise to an assessment of what the loss was, as well as other acts that make up the succession of events.
Well, in my submission, I'm not sure why that should be a distinction. I mean, and obviously there could have been a discussion of damage in this case, and in the Baltic case, one could have tried to establish jurisdiction in Lithuania, for example, by damage under Article 5.3. This case is exclusively concerned with a case in which one seeks to establish jurisdiction.
Well, damage in a competition case, I mean, it's slightly different.
Yes, and it has its own rules.
Yeah.
And just as in this case, there are rules about damage. They're Article 5.3, and we've already discussed them. At this stage of the appeal, one's focusing just on Article 5.5, and in my submission, what one's focusing on is what's meant in Article 5.5 by arising out of the operations of the branch. And in my submission, what the Court of Justice is saying apply LAL is that test, in order to meet that test, the branch must have actually participated in some of the actions constituting the tort. And it is put that way in paragraph 63.
No, I get 63 and 66.
Yeah. But when 63 says the branch must have participated, it's not suggested that will be sufficient and not a necessary.
I take that.
So. And if one tries to apply this to the facts of this case, the misstatements, of course, are exclusively the misstatements in the Hong Kong office. No allegation that anyone in London said or did anything that would give rise to an assumption of responsibility. No allegation that anyone in London made any misstatements or authorised them. No allegation that anyone in UBS London knew that the misstatements were made. And no allegation that anyone at UBS London encouraged Ace Decade to rely on what Mr. Wong was saying. And in truth, it's not alleged that anyone at the London branch had any dealings at all with Ace Decade or with Mr. Wong. And nor is it alleged that anyone at the London branch acted carelessly or acted wrongfully vis-a-vis Ace Decade. And in my submission, in a negligent misstatement case, if you can't show at least one of those things as having happened at the branch, it can't, in my submission, really sensibly be said that UBS London significantly participated in actions constituting a tort of negligent misstatement. And I, as I said before, whilst Fly LAL is the end of the authorities so far, apart from this one, on the subject, and so one only has what it says in the case. The clear implication by what they said needed to be investigated is that the branch should, if I can put it this way, should in some way be regarded as a tortfeasor or involved in tortious acts. Which makes perfect sense as a reason to establish jurisdiction to it. And of course, one of the problems with broadening the test to a more general inquiry into the factual connection between the branch and the dispute is that it makes the thing unpredictable and uncertain, because how closely connected does it need to be in order to establish branch liability? And in my submission, the way in which the court put the test in Phi LAL is a helpful and certain way of putting it, if one reads it as meaning involvement in tortious conduct means means having acted tortiously in some way. Going back to the judgment, there are just two other points that I should make. In paragraph 147, the judge referred to the fact that Mr. Wong, it was arguable that Mr. Wong should be analysed as acting as agent for UBS London. The judge doesn't explain what she had in mind by that. It doesn't, in my submission, make complete sense, because UBS London is not an entity. UBS is the entity, and that's certainly not a pleaded point. And then at paragraph 148, she concludes in this way. She says, one may also test it this way. How relevant will UBS London's thoughts and actions be to the trial? And then she says, well, the answer is that there will need to investigate UBS London's conduct and intentions at the time of the representations in the case and the loss resulting therefrom. Well, my lords, I don't necessarily disagree with that as a statement of fact, but that rather, if I may say, exposes the problem in the judge's approach, because that's looking at general factual connections, and it's actually dangerously close to saying that the Article 5.5 jurisdiction should be selected by reference to forum convenience factors. In other words, the location of the witnesses and where the investigation can conveniently be pursued. And that, of course, is not what the Convention is concerned with, and it's not what
Mr.
Article 5.5 is concerned.
There's no respondent's notice here, but could it not be said that your point about participation in the tort, since you're obviously right that UBS London is not an entity, but is simply part of UBS as a whole, that if Mr. Wong was acting for UBS, he was acting for UBS, including UBS London, in which case there was participation in the tort.
Well, but if I may say, that in a sense proves too much, because that would be the case in every entity with branches, that all of the, if one were to take that argument, if one was effectively to attribute the actions of employees at a particular branch to the entity, to the legal entity, because the branch is a branch, you would do that in all cases, and you wouldn't have to have the argument in Fly LAL, because it was simply...
You can't have it both ways. I mean, you can't have the judge is wrong in asking whether he was an agent for UBS London, and then say, well, in every case, it's the same for a branch as for the main entity.
Perhaps I should just make it clear that what I'm saying is that wasn't a reason.
Perhaps your best point is there's no respondent's notice on the point.
Well, I hope the point's a little stronger than that, because I would say that when I say she was wrong in saying that was a reason to establish jurisdiction under Article 5.5. It's not a relevant consideration in the branch analysis. And had a respondent's notice being filed, that is the point I would have made to it. And that's really, unless you Lordship have any questions, what I was going to say about Article 5.5. I mean, it is worth reminding. I mean, the matter of the roles is to focus on some of the questions on the factual connections with London. Ultimately, however, this has to be my submission of principled analysis of the nature of the investment. And this is a case where the claimant here, Ace Decade, is complaining about an investment that it made in China that took the form of contractual rights under a Chinese contract with a Chinese counterparty in shares traded on the Chinese stock market. And it complains that it was induced to do that by misstatements and advice received exclusively in China, in Hong Kong. And in my submission, there is really, properly analysed, nothing sufficiently to connect this case with England to justify jurisdiction under 5.3 or 5.5. So unless there's anything else I can help you with.
Thank you very much indeed, Mr. Quest. Mr. Hussain.
My Lords, my Lady, with your permission, what I'll seek to do first of all is to make a few responsive points on the general introductory points that Malone Friend made. And then I will take it in the same order of looking at 5.3 and 5.5, and in the same order as looking at the European cases, and then looking at some of the English cases. Just picking up on the original, the introductory points. First of all, I should say this is one of those happy cases where we say that the learned judge was right for the reasons that she gave, and we would say, although we may say this, that her reasoning was impeccable. And so we invite the Lordships and Ladyship to dismiss the appeal. Obviously, I'll come on to that. Now, in relation to the facts, my own friend started out by saying that absolutely everything happened in Hong Kong. I should just, and identifying this as part of the common ground, I should highlight paragraph 147 of the judgment, which is, although the judge did not base her decision on the position of Mr. Wong as agent for UBS London, she nonetheless said that it was certainly arguable that he was so, and that was a matter about which there was a substantial amount of argument below. The next point that Malone and Friend was...
Just before you go on, Mr. Hussain, may I just ask you whether you support actively, I think you do from what you've said, the second paragraph, paragraph 98? Because for my part anyway, I would like to hear your submissions on that, why that is correct. Where she accepts the submission that UMI, it's your submission I imagine, that
yes.
UMI appears to demonstrate that the location where damage manifests is identified from some objectively ascertainable step or act, forgive me, which crystallizes the loss and connects the two parties together. I'm interested to know whether you say that's right, and if so, why.
Can I give you a...
In due course. You don't need to tell me that.
The short answer is that I do say that is right.
Mm-hmm.
The interesting point arising from Malone and Friend submissions is that the central tenet of the judge's ruling, judge's judgment, was that there was a test through, in particular, Lobber and VEB, of looking for the place of damage where it actually manifested, cross-checked by reference to the purpose of the provision, including, for example, and probably most importantly, foreseeability of suit, but not restricted to that. So that is actually the kernel of what the judge decided. And I really came along today to make that point, but Malone and Friend, from what I detect, doesn't really resist the idea that there is this consistent line of authority in the CJEU cases, which is talking about actual manifestation as the touchstone. Now, once one gets to actual manifestation, then the question is, how does one actually arrive at that in practice? What can one say in order to amplify or confirm or look at in another way what actual manifestation may be? And what the judge found or held was that it is likely, she didn't say it is always the case, it is likely that manifestation will be found where the loss can be said to be crystallized. And I would invite your lordships and your ladyship to see that as an amplification, an elaboration, an attempt to look at in different ways this test of actual manifestation. And in my submission, the judge was quite right to look at it in that way because of the other European case, the UMI, which actually precedes Lobber and VEB. So it precedes the articulation of an express actual manifestation test. But what it does do is it uses what I would describe as cognate expressions, such as fixed, clear, and irreversible, placed an irreversible burden. Now, those were expressions that were used in reasoning the particular facts of that case to do with the settlement. But the judge in my submission was right to regard those as helpful amplifications of what one is looking for when one is trying to find where the loss has manifested.
Is that a sort of another way of putting the point I put to Mr. Quest about a European law looking at the substance of what happened rather than the intricacies of domestic tort?
Yes, and that is a part of it, but it's not, as it were, a free-form principle. It follows from the fact that when one's interpreting these provisions, one is always looking at it from an autonomous point of view. So one is not looking at it from the point of view of what does the domestic law require, and have the precise elements of that domestic law being satisfied, because one is looking to find results that are the same, irrespective of what the domestic law is. So that necessarily is one factor that requires one to some extent, look through the technicalities at the substance of the matter. But there is in my submission, there is a second aspect to this, which is that one might broadly define harms from torts into two categories, two broad categories. The first is you've got cases where you have some physical harm, and there is a financial loss that is consequent upon that physical harm. And those are cases like the Marinari case and the Dumes case, which we can look at later, time permitting. And so those cases are quite easy when you're looking at place of damage, because the place of damage is the place where the physical harm is. And they make it easy to distinguish between what might be regarded as direct and consequential loss. Now, then you have cases which are pure economic loss cases, and those are the cases that have occupied the CJU in the line of cases starting from Kronhofer and finishing up with VEB. And those cases are usually cases where it is more difficult to identify any harm, because there is no physical harm to property or person that, as it were, is the cause of consequential financial harm. The nature of pure economic loss is, because of the way the loss arises, the nature of the loss is that the claimant is simply financially worse off as a result of entering into the transaction than would otherwise have been the case. And the fact that it is that counterfactual calculation, it makes it difficult in some cases to identify the place of damage, because on one view, where you suffer your damage is wherever your wealth is, wherever your assets are. And that is the view that was roundly rejected in Kronhofer, where Mr. Kronhofer says, I feel the loss where my wealth is in Austria, so please give me jurisdiction there. And the court said, no, you can't say that the damage is suffered just where you feel it. So in the absence of saying that is the answer to the question of place of damage in economic loss cases, what you then have to consider is, what else is the yardstick? What else is the measure that I'm going to adopt when I come to arrive at the place of damage? Because in truth, in at least many cases, there isn't an actual place. It is a fiction or a figure of speech to identify a particular place. And I'll show you afterwards where the Attorney General in VEB makes that very point. And so what one is doing is trying to arrive at a legal fiction or figure of speech where one can say in an economic loss case, the damage has occurred. So when and where was this damage? And the court's solution to that, which my learned friend doesn't appear to resist or resist strongly, is actual manifestation. So, my lord, this is a rather long way of saying that looking at the substance of what is happening, looking at the events at which one can say now there is a loss, is to some extent a feature of trying to find a place for loss in a case of pure economic loss. And so what I say in short is that the judge has quite correctly taken up the actual manifestation rule or principle that one sees in those cases, and has then and has quite correctly seen that this is not something where one is necessarily identifying some readily identifiable physical harm to a claimant, and what that leads to, in particular, looking at UMI, is to ask the question: at what point and where did this loss become fixed, become clear, place an irreversible?
I mean, I think if I may say so, you would be wrong to say that he does not question the manifestation point. I think that Mr. Quest very clearly says that the judge was wrong, not only in the passage I put to you, but also in paragraph 111, where she summarised the manifestation argument. And he says that is completely the wrong approach, because the loss is already suffered, as he explained at length, when the transaction's entered into. And manifestation of subsequent loss is just assessment.
Well, what I meant by that, my lord, is that in the Skelton argument, what is said is that there is that the rule that my learned friend expresses is a general rule of place of commitment that is subject to an exception of place of payment in bank account cases plus special factors.
Yes.
So it seemed from that he was challenging the existence of a principle through the authorities that what one is looking for is actual manifestation.
But he's actually talking about place of payment when you made the investment.
Indeed.
That's the interesting. That's the interesting dichotomy, because the judge says the place of payment is what you lost, but he's talking about place of payment when you made the investment as being the loss.
Yes, and I will come on to all of that.
Which is China.
I will come on to explain why the judge was right in her approach on that in a moment. Oh, going back to the outline points, my lord, and my lady, where Malone Friend also emphasises is that these were all that the arrangements, the contracts that were entered into by Ace Decade were not with UBS, that the contracts that UBS entered into were with Dawn State, and so on. 2 points to highlight about that. The judge's description of the facts is not in dispute for you. Paragraph 33 identifies what we had emphasised without, and implicitly what the judge is accepting that this was a factually accurate description of what was going on, certainly our case. So at Judgment 33, it's emphasised that Dawn State was effectively part of a bespoke structure created expressly for this series of transactions. And she goes on to say that that Dawn State was not an independent entity transacting at arm's length from Mr. Quat and Ace Decade, but an entity in respect of whom they continue to play a close role, and so on. And that is a signal feature of this case, because whilst it can be said, and of course we accept, that the agreements that were entered into with UBS were not by Ace Decade, nonetheless, it was a part of a single bespoke investment structure. Nonetheless, the moment when these shares were enforced against in the custody account with UBS, it was absolutely clear that Ace Decade had suffered the loss of the great part of the $500 million monetary contribution. In terms of the suite of arrangements, one point that I should perhaps also highlight is the fact that in the letter agreements that you were shown, going to SB 252, there were agreements that the investor, that is to say Ace Decade, should be primarily and solely responsible for all the fees, costs, expenses and payments in connection with the financing. And also on SB 253, further agreements, undertakings by the investor to compensate and indemnify the company, Haisha and Haisha Management, of any amount paid by the company as the borrower of the financing, and so on. So the link and the interface between the agreements went as far as Ace Decade ultimately bearing responsibility for all of the costs of the funding. Well, the next aspect that Malone and Friend emphasised in opening was that one ought to look at this as a matter of first impression. And so he said that the loss was when they parted with the money, when otherwise they would not have done so. Plus, they have not got the money back. And it is, in our submission, very clear, and the judge was right to think that it is the second aspect of that is necessary to when the damage, in a substantive sense, has occurred. And my Lord the Master of the Rolls raised a question to which the answer was that as to whether or not there would have been any claim if the shares had fallen. To which the answer was that it wouldn't have been formulated in the way that it was if there hadn't been any margin calls. But that, I do submit, as a rather unreal submission. There wouldn't have been a claim. because no margin call would have been made. If this investment, as it might well have been at the time of investment, had been a great success, then these misstatements about the policy of UBS London with regard to margin and prepayment would have made no difference whatever.
Why wouldn't there have been a claim for damage though upon entry into the transaction? Saying this is not what we bargained for, now we know there's no policy, might go up, might go down, we want out. We shouldn't be here at all.
Now, in principle, you might have a rescission claim if it came to light afterwards, but it's perhaps relevant in this case that the claim is not that Ace Decade was misled as to the terms. It is that it knew exactly what the terms were. It was just told that those terms, there was a policy of not enforcing those terms. So the reality is that it all went wrong when UBS London in fact enforced the policy, or in fact enforced the terms according to their terms. So it's perhaps a little bit difficult to see a scenario where this would have come to light otherwise. But in any event, it would have been a very different claim. It would not have been the claim that is made here for the monetary contribution less the 4.7 million. And so it doesn't assist Malone and Friend to say, well, there might be circumstances in which a claim could have been formulated differently so that there would be a claim arising following entering into the agreement. Because what the judge and your lordship and ladyship are concerned with is how does one characterise the damage in this claim? The next preliminary point was to look at the pleading, and you were shown paragraph 83 of the particulars, which Malone and Friend described as the pleading of loss. In fairness, he did also take you to 84, and the two obviously need to be read together. But the important point, and this was again debated before the learned judge and dealt with by her at paragraph 62, Malone and Friend wants to say that actually the pleaded loss, if it were right to focus on the pleading minutely in this way, is at 83 in referring to entering into the co-investment agreement. This is CB 154. But in fact, the judge was quite right to point out that what 83 is pleading is the acts of reliance. It is not pleading loss and damage. The pleading of loss and damage comes in 84. UBS's negligence has caused Ace Decade loss and damage. And the loss and damage is set out, or the primary case is set out at 1. It's the 500 million monetary contribution, less the $4.7 million that was recovered. So it is important in our submission to note that even if one were to look at the formulation as opposed to the more broadly at the substance of the claim, then what you would be looking at is a claim that is formulated in terms of the 500 million less the 4.7 million. And of course, one can test my learned friend's proposition that all was lost when the $500 million was paid by way of monetary contribution by asking, is that our claim? Is the claim for the whole of the $500 million? And the answer is no, it's not. It's a claim for $500 million less 4.7 million that was recovered. When was it known what the amount of the 4.7 million that was recovered was? Not until 6th to 8th July 2015, when the security was enforced. there is another. My Lord, the Master of the Rolls also put it to my friend that the complaint, his complaint, or rather our complaint, is that UBS enforced when you said that you wouldn't. And my own friend resisted that because it's his position that the loss is when you enter into the agreement. But one can test that in another way, because it's one part of Ace Decade's case that representations were made to induce it to enter into the co-investment agreement on a false basis. It's another part of its case that representations continued to be made after the co-investment agreement was entered into, but before the Haitong shares were subscribed for, at a point when it could have yet withdrawn from the co-investment agreement. And so that rather disproves the notion that one can have damage treated as at the time the agreement is entered into, because the representations that we rely on for the purposes of our alternative case continued after that. And that gives rise to a different loss case, which is the loss case that's pleaded at paragraph 84.2. And that loss case is that it's a claim for the 500 million monetary contribution, less the 4.7 million that was recovered, but also less the fees that were payable upon entering into the co-investment agreement that would not have been recovered had that agreement been entered into and then withdrawn from. I see the time. Would that be a convenient moment?
Yes, I think it would, if that's convenient for you. Good. Well, we'll rise now and see you at 2 o'clock.
All right.